So again, this is an important chapter both for the test and for doing business. Just to whet your appetite a little bit, this is a list of some of the properties that will be on the sheriff's sale. Now, when I originally posted this, the date was going to be 6/10/20. They're still not holding the sheriff's sales yet. They're still in forbearance, waiting until we get a little bit further out of the corona situation. But there is Middlesex County's website. Just Google Middlesex County Sheriff's Sale, and you'll see a picture of the sheriff. Just follow her links on there to the sheriff's sale. There'll be some disclosures about how the sale works, and you can look at these yourself. And again, if you're a real estate agent, you might notice that this person at 20 South McKinney Avenue in Island, you might notice that they are going to be foreclosed and they're going to be at the auction. You might want to approach them before it gets to the auction and see if you can list their house for sale, or see if you can produce a buyer for them before it hits the sale. Just some of the things that you can do. You can see that it's Wilmington Savings Fund that's doing business as Christiana Trust is what it is. That's the foreclosing entity on this. I get a lot of listings. I do a lot of business with bank-owned properties, and this is how I track down the banks to see if I can get them to give me more business. I just look at who's foreclosing. People sometimes ask me, can I call the bank directly and see if I can buy that house before the sale? The answer is no. You can contact the defendant, that's the owner, and see if he wants to sell it to you before the sale. But the bank has no say in what's going on with that specific transaction until after it gets sold at the sheriff's sale. So you can't go to the bank and say, I'd like to buy the house. Once you have your license, you could go to the bank and you could find the asset manager. And usually we're looking for the REO department. The REO stands for real estate owned. You're looking for the person who manages that REO department, and you'll approach them and you'll say, I'm a real estate agent and I'm really good, and I would like to know if I could get some of your properties that you own that you need to sell. I would like to be an REO salesperson, REO agent. And I probably do about 30 of those transactions a year. So half of my business is with bank-owned properties. And in years past, maybe I would do 40 transactions a year. That's a large part of business. So it's something that you might want to consider. All right, so we're talking about encumbrances to start off. An encumbrance is something that you carry. So this donkey has an encumbrance. He's carrying a pack. It's something that weighs down or complicates his walking in the mountains. That's an encumbrance. And what an encumbrance is something that complicates your ownership. And there's different types of encumbrances. Encumbrances could be a lien. An encumbrance could be a covenant. An encumbrance could be a security interest. It could be a servitudes. That's a type of easement. It could be wayleaves. All different types of things could be an encumbrance. It could be a deed restriction. It could be an encroachment, and it could be air and subsurface rights. All those are considered as potentially making the title defeasible. All those are things that make the title able to be defeated. For example, charging orders, building orders, and structure alteration. There are encumbrances. They could be a charge or claim against the land arising out of a private grant or a contract. So anything that complicates your ownership, just like our friend the donkey here, anything that makes his job harder, it could be an encumbrance. A lis pendens, and that's a very important word to know. A lis pendens, that's Latin for lawsuit pending. So in New Jersey, a lis pendens is Latin for lawsuit pending. And a lis pendens is what the lenders do. They file a lis pendens. When they're beginning their foreclosure process. So if you're looking at Zillow, and you see a property that's listed as pre-foreclosure, what that means is that the lender has filed a lis pendens, and that particular buyer is on their way to get foreclosed. And it says here that with a lis pendens, a buyer would be held subject to the outcome of the litigation. And we had talked the other night that in New Jersey, our foreclosure is a judicial foreclosure, which means it's a lawsuit, it's litigation. And so if that lis pendens is filed, and then using the mortgage to allow a foreclosure to take place, I'm sorry, my water got in the way of my drawing there. I apologize about that. If a lis pendens is filed and the foreclosure is happening, the person could be held charged with the outcome of that foreclosure. In other words, he could lose his house. He could lose his house. There's all kinds of lis pendences. There's quiet title actions. There's mechanics liens and foreclosure. Also, sometimes they're part of a divorce process, because we know that if the property is in one party's name only, if it's in the husband's name only, there could be a dower right for the wife. And if the house is in the wife's name only, there could be a courtesy right for the husband. So again, a lis pendens is Latin for lawsuit pending. A lis pendens is Latin for litigation pending or lawsuit pending. And it's something that we always want to be aware of. Why? Because it's public record. And since it's public record, what it means is that we can know about it. You can go to the county clerk's office and you can get a list of all the properties that have lis pendences against them. And that might give you an idea of which properties are proceeding towards foreclosure. Or you can buy that list of lis pendens. You could buy that list of New Jersey lis pendens. When you look at Zillow and you see a pre-foreclosure, how does Zillow know it's a pre-foreclosure? Because they buy the list of lis pendens, and they just make a note of that property moving towards foreclosure. So when does the foreclosure process begin? In real life, it begins when you miss about 3 payments. When you're behind 1 or 2 payments, you go into what they call mitigation, and the lender will try to get you to make payments, even accept partial payments. Once you get beyond 3 payments, typically the lender is bound to begin the foreclosure process. Typically, they're bound to begin the foreclosure process, and they initiate foreclosings. Sometimes they could initiate for just 1 payment, but normally under federal law, in most cases, the lender can't officially begin the process until you're 120 days late. So that's you're on your 4th month that you're late. After 3 months, that's when they're allowed to do it. Under the New Jersey Fair Foreclosure Act, before your lender can file a complaint against you, there's certain things they must do. And some of the things they do is they may be forced to offer you a modification. They don't have to give you one, but sometimes they'll review the process of getting a modification. The next thing they do is they're going to file a notice of intent to foreclose. They're going to do a title search on the property to see if there's any other liens. And again, if there's other liens, the lender that is foreclosing is under an obligation to let the other lien holders know. So again, there's a whole big long process. And in New Jersey, in order to foreclose, it takes 4 years. That's one of the longest in the country. There's only one state that is longer. All right. When they file their original intent to foreclose, if no answer is filed, or if it is determined to be a non-contested matter, the mortgage lender can ask the court for an entry of default. And then after 35 days, you get a summons. They tack it on your front door. They have some more time frames they have to go through to give you an opportunity to cure your default. And when they do all that, they will schedule your home for sale. So when they go through all of that, you will get a notice telling you when your home will be scheduled for sale. And when they give you that notice that your home is going to be scheduled for sale, the notice has to be posted somewhere. Usually it's in the home news, and it's posted for 2 two-week periods. So it has to be posted for 2 fortnights. Fortnight is 2 weeks, has to be posted for 2 fortnights. So if you know which day to buy the home news, you can see all the scheduled sales that are coming up. even if they're not yet showing on that first page we looked at today. The lender will then serve you with the foreclosure complaint. You're going to have it published in your local newspaper. Unless you have exceptional circumstances, they will move the process along. You might be offered mediation. Mediation does not stop the process. You're still going to be moving towards the sheriff's sale, and then you will be scheduled at the sheriff's sale. When you're scheduled at the sheriff's sale, once you are scheduled at the sheriff's sale, you can request a 2-week delay. It costs you $28 to do a 2-week delay. And you can do that 2 times. You must file a written request, right? And you can do it 2 times. The lender also has the ability to delay the sale twice for 2 weeks. So for instance, if you're getting close to being able to sell the house and pay off the lender, it might be in the lender's best interest to delay the sale. So all of this stuff is, on the test, it's not going to be quite this detailed on the test, but this is stuff that you really want to know because you are going to work towards marketing to people who may be losing their homes, people who may be on this track to being foreclosed, because being foreclosed is really bad on your credit. And we talked the other night in the mortgage chapter about potentially you could do a deed in lieu of foreclosure. And we have another option. The other option is to do a short sale. And a short sale is when you negotiate with the bank. It's when you negotiate with the bank, so the bank will accept less than they're owed in order to let you sell the property. Keeping in mind that on a short sale, the seller cannot receive any benefit. Now, if the property is sold at the sheriff's sale in Middlesex County, the person who just lost the house has 10 days to redeem. They have a 10-day period of redemption. That 10-day period of redemption means that if you can come up with all the money that you owe the bank, not just what payments you're behind, but all the money, if you can come up with all the money that you're behind, then the bank will allow you to redeem the property. So in Middlesex County, when they have the sheriff's sale, it's on Wednesdays at 1:30, every Wednesday except during this COVID situation. When they have that sale, whoever is the winning bidder is not going to get their deed for 14 days. Why are they not going to get their deed for 14 days? Because there's a 10-day period of redemption. And so during that first 10 days, the homeowner has the right to come up with all of the money. That's not just what they're behind, that's all of the money, and they can redeem their property. Now, we talked about in the chapter on mortgages, when we talked about assuming a mortgage, remember we talked about the mortgage and the note, connecting both parties to the promissory note and allowing them both to be sued for a deficiency judgment. So again, if a lender gets a deficiency judgment, you get 6 months after the entry of the deficiency to redeem. And that means if the lender forecloses on your house and you owe the lender $300,000 and they foreclose on the house and they sell it and they only get $200,000, then you're going to have a deficiency judgment of $100,000. You get 6 months after that entry of the deficiency to redeem. And that means to pay off that deficiency judgment so it doesn't get entered against you and serve as something that hurts your credit. When you are negotiating for a seller to do a short sale with the bank, one of the techniques you should always use is you should always ask the lender to waive the deficiency judgment. And if they waive their deficiency judgment in the short sale negotiations, it means your seller, who is after all losing his house, is not going to be burdened with a deficiency judgment, which again certainly hurts your credit also. So again, we have a class on short sales, and we'll go over this in the techniques very, very much more in depth in that class. But for passing the test right now, the main things you need to know is that at a sheriff's sale, if you're the winning bidder, you get a sheriff's deed. If your home is sold, you could have, it could be sold for more than you owe the bank. That's an equity of redemption, and that allows you to make an opportunity to make an application to get that equity of redemption back. If a winning bidder gets the bid and wins the auction on your house, they're going to get a sheriff's deed. And when we talk about the chapter on deeds, we'll talk about how a sheriff's deed differs from a bargain and sale with covenants against grantors' acts deeds. And if your house sells for less than is owed the bank, there could be a deficiency judgment entered against you. So your house is only worth $200,000, but you owe $300,000. You know you're not going to be able to refinance because you've already trashed your credit by not paying for the last 3 years. What are some alternatives to foreclosure? We talked about deed in lieu of foreclosure on the chapter on mortgages. A deed in lieu of foreclosure is where the original owner will prepare a deed and deed the house back to the lender. Now that doesn't always work in New Jersey because if you've got a loan that's guaranteed by the US government, that's a VA loan, or if you've got a loan that's insured by the US government, that's an FHA loan, or if you've got a loan that is a conventional with PMI, the benefits of those guarantees or insurance policies do not apply unless the lender forecloses. So if you do a deed in lieu of foreclosure with the lender would not get their VA guarantee of $86,900, or would not get their payment from FHA, or would not get their payment from the PMI company on a conventional loan. So in many cases in New Jersey, the lenders will not accept a deed in lieu of foreclosure. And this is where this stuff gets really interesting and all connects. When we talk about deeds, in order to have a valid transfer of real estate with a deed, the last condition of a deed, so a deed has to be in writing, it has to have competent grantors, it has to have a legal description of the premises, that's a meets and bounds description, it has to have a statement that says how much you're paying for the property, and it has to have delivery and acceptance in the here and now. So in order for a deed to transfer property, there has to be delivery and acceptance in the here and now. And if the bank is deciding not to do a deed in lieu of foreclosure, and you bring them a deed and say, here's the deed, I don't want the house anymore, they don't have to accept that deed. And if they don't accept the deed, it doesn't transfer ownership of the house, because you have to have a delivery and acceptance in the here and now with the deed. All right. Second thing is a short sale. A short sale is when you ask the lender to take less money than they're owed for the house. So a good example is you owe the lender $300,000. Your house is only worth $200,000. That's all it's worth. And you've got a buyer who's willing to pay $200,000. But in order for that buyer to close, the bank has got to release its lien. So when you do a short sale, you say to the bank, listen, I know we owe you $300,000, but we're only going to give you $200,000. Will you release the lien? And a short sale is where the bank says, yes, they're going to release the lien. Now, you know, there's interesting things about short sales, because if you look at this, really the bank just lost $100,000 because they were owed $300 and they're only getting $200, so they lost $100,000. That bank has the ability to send the person who lost their house a 1099 for that $100,000. So imagine you lose your house, you ruin your credit, your house gets taken away from you, or your house is about to be taken away, and you do a short sale, and then you get a 1099 for $100,000 worth of income. That's not a nice day. So again, you know, when we're working with these short sales, and we're working with people who are about to be foreclosed, there's a lot of ways we can help them. And if they listen to us and they take our advice, sometimes we can save them a lot of money. We also have a Service Members Civil Relief Act. This makes it a little bit more complicated to foreclose on people who are on active military duty. Because after all, if somebody's been in Iraq for the last 2 years fighting, and he's being foreclosed, he may not have the ability, or she may not have the ability to get all the notices. And so therefore it's a little more difficult, a few more hurdles to have to jump through to foreclose on somebody who's on active military duty. Typically, this is the notice that's posted on your door when there's gonna be a sheriff's sale. Plus, you're identified in the newspaper. Very embarrassing to people when they're identified in the newspaper as someone who's about to lose their house in a sheriff's sale. So I caution you, when you approach people in order to try to solicit business from them, do it with your hat in your hand. Go there humble and go there very unassuming and quiet. And sometimes, you'll have to suffer their wrath for a few minutes before you can get to listen to you about the ways that you might be able to help. Okay. Next thing we're going to talk about is real estate property taxes and assessments. On the very first chapter, we talk about sometimes that you have two obligations to your real estate. Obligation number one is to pay your real estate taxes, and obligation number two is not to waste. Not to waste means adverse possession. So when we own a real property, we have an obligation to pay real estate taxes, and we have an obligation not to waste, which means to know enough about your property to know what's going on there so that someone else can't create a claim of adverse possession. So, real property taxes, that's how your municipality funds its operations. Most of the real property taxes, by the way, go to schools. Our schools in New Jersey are all funded, or mostly funded, by municipal property taxes. And many of the largest cities in America and many of the largest cities in New Jersey, and this was January 29th, 2019. Imagine how bad it is now because of all the revenue that stopped coming in from Corona and all of the extra expenses. We are going to have a big crisis in terms of municipalities being able to afford their budgets. If you do not pay your real estate taxes, and if you own the house outright, you have no lender. If you own the house outright and you have no lender, or if you've got the kind of loan that allows you to pay your real estate taxes direct, the city, the municipality counts on your taxes. And if you do not pay your taxes, it affects their budget because they're going to collect less. They may have to borrow money in order to run the city because every municipality runs at 100% of what they get in, they spend. Nobody really runs a surplus. And so they need your tax revenue. So the rule here, the law here, is that if you haven't paid your taxes on the 11th day of the 11th month of the fiscal year, anytime thereafter, they can auction off your taxes. So you didn't pay your taxes of $10,000. Now the municipality has the right to ask investors to pay those taxes of $10,000. And so you didn't pay your $10,000. They ask investors to bid on the right to pay those taxes for you. The bidding starts at 18%. And typically, it's hedge funds now that are bidding. 20 years ago when I used to go to these tax lien sales, it was just me and a bunch of other guys with suitcases full of money. But now it's hedge funds. And typically, the hedge funds will bid, and they'll bid it down to 0% interest. And they'll even have 0% interest plus a premium. So they'll be giving the town $500 plus the $10,000, and they'll get 0 interest. Now, why do investors bother to do that? Why would an investor pay your taxes for $10,000, have the town hold the money, and get 0 interest? Well, the reason is they ask that sale be done near the end of the year, like on the 11th or 12th month. And so if we're doing that sale on 11 of 19, and here's 1/1 of 20, the investors buy the lien and they pay the $10,000 here, and they're getting no interest here, and they're getting no interest for the next year, all the way up to 11/19 of 20. However, on 1/1 of 20, that's when your next year's taxes come due. And so the investor then is allowed to pay next year's taxes, which are $10,000. And on that $10,000, he gets 18%. And because it's over $5,000, he gets an extra 2%. and he gets a 2% redemption penalty. So on the second 10,000, he's getting a total of 22%. So on the first 10,000, he's getting 0. On the second 10,000, he's getting 22%. So that's somewhere around an 11% yield. And 11% yield is really high nowadays, right? You put your money in the bank, you're only going to get 1%. And that's a very safe investment, paying a tax lien, because tax liens and unpaid taxes automatically jump to first position. Even if they're not recorded, they jump to first position. And if you're an investor and you buy one of these tax lien certificates, you record it. So now you're in first position. And that means if you foreclose, everything underneath you is wiped out. So if you're an investor and you buy one of these tax lien certificates, there is a 2-year period of holding. So if you hold a certificate for 2 years and the homeowner does not pay you back, then you can foreclose. So on a normal tax certificate that's purchased by just an investor, the period of holding before you can close is 2 years. If nobody bids on the property, for instance, let's say you've got a lot and that lot is not a buildable lot and the taxes on the lot are $2,000 a year, nobody's going to bid on it because they can't do anything with that lot. So they know that nobody's going to pay them, and they know that they can't foreclose and make any money on it because it's just an undersized lot. So therefore, nobody bids. If nobody bids, the town buys it back. And when the town buys it back, it's called in rem. And when it's in rem, the town only has to hold it for 6 months before they can foreclose. So a normal certificate has to be held for 2 years. In rem only has to be held for 6 months. And a business strategy is to approach a town and say, hey, Mr. Tax Collector, what lots you have in rent, or what houses that are in really bad shape do you have that are in rent? And typically, that tax collector in that town will sell you those in rem certificates for pennies on the dollar. Now you still got a problem because you still have an undersized lot. So why would you even pay pennies on the dollar? Well, one of the techniques is if the town sells you a lot that's in rem, then they have to be able to have you derive some value at it. And so what you do is you file a builder's remedy suit. And as long as there's some way that you can build a house on that property, even though it's undersized lot, the town has to let you build on it. That's called the builder's remedy suit. The town is not able to sell you a property that you can't do anything with. They have to give you some kind of a remedy. So that's a technique investors use many times. All right, so again, it's a 2-year holding period for just regular, and it's a 6-month holding period for in rem. Here is a list of, I don't know what town this is, Teaneck. Here's a list of the tax lien sale in Teaneck from December 13th of 2019. They always hold it sometime after the end of November. We saw. And the first guy, Mr. Singh, he owes $3,086.11 in taxes. 391 Thomas Street, 2408. You see some big ones here, 11,965, 11,178. And this is probably 1 page out of 20 pages. Teaneck's a pretty big town. So this is, you know, a hedge fund might come in, and some hedge fund guy who bids for a hedge fund might bid on a whole bunch of the liens. You know, he might buy all the liens, you know, from the first one to the 30th one. You might buy all of these, okay? And you can buy them too. Usually the bidding, again, remember the bidding starts at 18%, and usually the bidding goes down to 0%. Because even at 0%, you're getting an 11% effective yield when you pay next year's taxes. Very, very cool thing. In the olden days, hedge funds didn't participate. It was just all local guys. Now it's all hedge funds. Yep.
Someone texted if we let them in.
Okay. Excuse me 1 second. Someone has texted, they're waiting to get in. They are probably on the morning email. Send that note. Yeah, I wasn't quite awake at 6:30 this morning, that's for sure.
Yes, Bruce.
They're probably working off of this morning's email that said
Okay, I'll
6:30,
double check.
and so send them the afternoon email.
Really quick, Tom's having trouble finding Bridges in Fort Reading.
It's Forge. It's off of St. George's Boulevard. Oops. Let's get back here where we are. All right, tax lien certificates. Interest starts at 18%. It goes down to 0 with a premium. If you don't pay it within 2 years, the lien holder can foreclose just for the unpaid taxes. If no one bids, then the town buys it. When the town buys it, it's called in rem, and the holding period is only 6 months before the town can foreclose. Usually the towns don't like foreclosing, so they'll sell you the in rem certificate before the foreclosure period, and you'll have to foreclose yourself. When you're foreclosing on a tax lien certificate, it's probably $5,000 to foreclose on a tax lien certificate. Not real expensive. 99% of tax lien certificates get redeemed, because who might redeem a tax lien certificate? Well, if you've already got a mortgage and you've got a mortgage for $200,000 on your house, and that mortgage is in first position, remember, position is established by time and date of recording, and you owe $10,000 in taxes, and an investor buys that $10,000 lien jumps to first position, because unpaid municipal taxes automatically go to first position. Now your mortgage lien is in second position, and if you foreclose after 2 years, because you're in first position, this gets wiped out. So what typically happens is if there is a mortgage on the property and there's a tax lien certificate that's obtained on the property, the lender will pay off the certificate. And when the lender pays off the certificate, remember we said whenever you break your promises that you made to your lender, they accelerate your loan. So if the lender was all of a sudden in second position and was forced to pay off the tax lien certificate, the lender would accelerate the loan and begin the foreclosure proceedings. Other kinds of liens that can happen is a mechanics lien. A mechanics lien can happen if a contractor does work on your property and you don't pay him. That mechanics lien has to be filed. Within 90 days of the delivery of the last material or the completion of the work. And that mechanics lien only applies against the property that is worked on. It's an involuntary lien. The contractor does not need your permission. And whatever the time and date of recording is, establishes priority. So typically the mechanics lien is in a much lower priority. It's usually a second or third lien. Now, we talked about last night when you do a construction lien that they don't want to give you all the money at once. So first they're going to give you the money to do the framing on your house. And then you're going to have the inspector come out to your house from the bank and make sure you did the framing. And then the inspector is going to say it's okay. And they're going to give you that money then to pay for the framing. They're going to give you the $20,000 to pay for the framing. And when you pay the contractor for the framing, and when you make that contractor happy by paying him, the contractor is going to give a lien release to the property owner or to the general contractor, because it's going to remove the possibility of that contractor filing a mechanics lien. So we get a lien release so that that contractor cannot file a mechanics lien. So again, a mechanics lien is an involuntary specific lien. It's only against the property that the contractor did the work on. The next thing is an attachment. An attachment acts as a lien, and you can get a writ of attachment that attaches it to a property. It is acting as if it's a specific lien just on one property. Now, the way this works, among many other ways, is you've got a nice house, and this guy is going to sue you, and you think he might win. You might really quickly sell your house, convert it to cash, right? Because you're going to sell it, and then take off. Then if he wins his court case, because it takes 2 to 3 years to get into court, there's nothing for him to attach to or to collect. So what this does is he goes to court first, and he tells the court, listen, I'm getting ready to sue this guy, and I think I might win. I want you to put a writ of attachment. And what that writ of attachment does, it acts as if it's a lien, but it's not quite a lien yet. It would become a lien upon the culmination of whatever lawsuit is going on, but it stops this guy from selling his house and taking off. That's a writ of attachment. It acts similar to a lien. Then we have general liens. General liens are liens that are against all property, both real and personal, both real estate and personal property. Typically a judgment, when you go to court and you get sued and you lose and you get a judgment against you, that becomes a general lien. It's against all property. It's involuntary. A judgment lien does not need your permission. It's an involuntary lien. Again, a writ of attachment is also an involuntary lien, but a writ of attachment is a specific involuntary lien. Writ of attachment is a specific involuntary lien. And the last lien that we're going to talk about is the lien that's created when you die. When you die, the decedent's debts become a lien against the estate. When you die, you have to pay off all of the creditors of the dead person before any of the assets are distributed. And if you die and your estate is worth more, and I think the number is 2 million now, I'm not sure. It used to be 600,000, but Trump raised it to 2 million. If you die and your estate is worth more than 2 million, there's an automatic lien created for your federal inheritance taxes. So again, that's something that always pops up with real estate because it's easy for people to have more than $2 million worth of assets. So again, those are all different types of liens. Remember, a mortgage lien is a specific voluntary lien. A mechanics lien is a specific involuntary lien. A general lien is an involuntary general lien. A judgment lien is an involuntary general lien. And the debts that are created by the decedent's death as part of probate, those liens are involuntary general liens. So liens can be specific or liens can be general. And remember, a mortgage is a voluntary specific lien. A mortgage is a voluntary specific lien. And again, when you're interviewing somebody and they're the executor of an estate, you want to remind them that if we think their estate is more than $2 million, and again, it used to be $600,000, you want to tell them to file the lien release claim, where all they have to do is sign an affidavit that says the estate is worth less than X amount of dollars, and it releases that lien. And that allows the property to be sold, because without releasing that lien, the property can't be sold. All right, so liens are a type of encumbrances. So a lien is an encumbrance. One of the questions on the test is, the correct answer is all liens are encumbrances. We know that because a lien is a type of encumbrance, but not all encumbrances are liens. And we know that because an encumbrance could be a lease, an encumbrance could be a deed restriction, an encumbrance could be an encroachment, or it could be a lien. So liens are always financial. Liens are always financial, and liens can be voluntary or involuntary. A mortgage lien is a voluntary lien, a tax lien, a mechanics lien, a judgment lien are always involuntary liens. And liens can be general or specific. A general lien is a lien against all property, real and personal. A specific lien is against just one property. So again, the lien that's created by you giving the bank a mortgage is a voluntary specific lien. Excuse me. On your property taxes, your unpaid liens on your property taxes that are created even without it being recorded, those are involuntary specific liens. Your unpaid real property taxes are only a lien against that specific property. The priority of lien is established by time and date of recording. We looked at that last night. Again, when you bring something in to be recorded, it's time and date stamped. And the time and date of recording, whoever records first has the first lien, and that's the one that gets paid off first in the event of a foreclosure. Positions of a lien holder can change. If you have a first lien and a second lien, the second lien holder is at bigger risk, and the second lien holder could, under certain circumstances, ask if the first lien holder will let him go first. And the thing we do that with, the document we do that with, is a subordination clause. We're asking the lien holders to change position. That's a subordination clause. Whatever is recorded first is a senior. Whatever is recorded later is a junior. And again, a first is senior to a second, but a second is senior to a third. And a third is junior to a second. And a third and a second are both junior to a first. So junior and senior just refer to relative priority, and whatever is recorded first is the biggest, has the highest priority. Whatever is recorded first has the highest priority, and that's the one that gets paid first in the event of a foreclosure. Mortgages themselves, and we went over mortgages last night. Mortgages hypothecate a property as a security for a debt. Hypothecate means to pledge. They like to put that word on the test. Remember, doctors take the Hippocratic Oath. The Hippocratic Oath is where doctors pledge to first do no harm. Hypothecation is a pledge of a property as a security for a debt. Remember, it is the borrower who gives the mortgage. So the borrower is known as the mortgagor. The borrower gives the mortgage. Therefore, the borrower is the mortgagor. The lender gets the mortgage. Therefore, the lender is the mortgagee. Who benefits from the mortgage? The lender benefits from the mortgage. Because if you don't pay the lender uses the mortgage to take your house away from you. Unpaid municipal taxes and tax lien sales always jump to first position. Always are senior liens. Even if they're not recorded, they are a senior lien. So unpaid taxes and tax lien sales are always in first position. All right, that's the chapter that liens, foreclosure, and redemption. Any questions?
Bruce,
Yes.
this might be a little bit off topic. Just a quick question. Can you tell me briefly what the definition of first look initiative?
So some of the big servicers, Fannie Mae, Freddie Mac, Hudson Homes, some of the big servicers write mission statements that say that all of these foreclosed properties that they have, all of these foreclosed properties where they've foreclosed against homeowners, it makes them look bad because, you know, everybody hates to have their house foreclosed. And when they foreclose a lot of houses, especially when they've done bad things, like do bad loans or mislead people about how they might be able to modify, when they do bad things, they have bad public relations. So in order to get better public relations, what they do is they put first look initiatives out there. And what they try to do with first look initiatives is they try to let the person who's going to buy the house and live in it have first priority for the first period of when it's on the market. So Hudson Homes is 7 days first look period. Fannie Mae is 21 days first look period. So those are all ways that they try to make it, they stack the deck so that owner occupants get the highest priority.
Okay, and does that has to be cash, or are you able to finance the first look initiative house?
In the first look initiative, they don't care whether it's cash or whether it's financing. They do care that it's owner occupant. That's really all they're looking for. They're trying
Okay.
to promote owner occupants, because owner occupants stabilize the neighborhood, where people who buy to be landlords don't stabilize the neighborhood.
Got it. Thank you.
All right, the next one is federal laws affecting real estate. Okay, so the first one is the Truth in Lending Act. This was part of Robert Kennedy's Attorney General's push to make sure that borrowers knew the true cost of borrowing money. And in the Truth in Lending Act, 1968, Truth in Lending Act was passed. In terms of real estate, what it did was it protects consumers in their dealings with lenders and creditors. It mandates disclosure of specific pieces of information before extending credit. And they do this through something called Regulation Z, like in zebra. Yeah, the lender has to disclose the APR, the term of the loan, the total cost to the borrower, what that loan is going to cost them. And in that total cost of the borrower is not the interest they're paying, it's also all the fees they're paying to initiate the loan. So when you get your Regulation Z, for instance, when you're getting your Regulation Z, you might have gotten a 4% loan from the bank, but your Regulation Z is going to come back and it's going to say your APR is 4.4%. The reason is that extra 0.4 is on there because all of the costs involved in originating your loan are also calculated into that APR. And that might be something like your appraisal or if you're paying a application fee or a commitment fee, that'll show up in that disclosure. So we need to get a Truth in Lending statement, and that Truth in Lending statement has a Regulation Z that requires specific disclosures about the terms and conditions of the loan and the total cost of the borrower and the APR, the annual percentage rate. Other required disclosures: identity of the creditor, a payment schedule, any prepayment penalties. Remember we talked about that last night. You borrow $300,000 for 30 years, you pay it off after you hit the lottery in your first month. You might have to pay back $315,000. Okay, no prepayment penalties on purchase money mortgages on New Jersey chartered banks. So again, it would have to have been a refinance or a commercial loan. If there's any insurance charges like PMI or MIP, any late payment charges, a description of the collateral, and the collateral is going to be your house. What demand features, and we talked about those things that might accelerate your loan last night, and if there's any prepaid finance charges. Now, another thing this law does is it gives a right of rescission or a cooling off period of 3 business days, including Saturdays. Remember, attorney review is 3 business days, not including Saturdays, Sundays, or holidays. Well, this right of rescission on loans is 3 business days, including Saturdays. This right of rescission does not apply to mortgage loans to purchase a house. And there's a reason for that, but just remember, it does not apply to mortgage loans to purchase a house. It does apply to refinancing. So if you're refinancing to get a lower interest rate, or you're refinancing to get some cash out, if you're getting cash out, you're not going to get your check until after 3 days because there's the 3-day right of rescission. And I'll tell you another trick to be aware of. When you go to buy a car and you finance it, the dealer will say, well, the loan is not fully approved yet, but you're good. Take the car home anyway. And you take the car home. Well, when they told you the loan is not good yet, what they mean is the 3 business days for the rescission has not passed yet. So sometimes unscrupulous car dealers will tell you to take the car home, and you're showing it off to everybody, and everybody on the street is coming out, saying, wow, what a nice car. And then they call you the next morning, because it's still within the 3 days, and they say, listen, bring the car back. We're not going to give you the loan. And you say, well, why not? And they say, oh, something, it's on your credit, something happened. But that's not what they're really doing. They're really using their 3-day right of rescission to bring you back. because they're going to try to give you a higher interest rate loan. And it's something that they do all the time. I bought a Kia Soul, and when I bought the Kia Soul, one of the documents they gave me was a document that said, I hereby give up my rights to 3-day right of rescission. And that's totally baloney, because this is a federal law, and you get that 3-day right of rescission on financing anyway. So again, we don't have this 3-day right of rescission on a mortgage that you're purchasing your house with, but you could have this 3-day right of rescission, which is 3 business days, including Saturdays, on a refinance. Okay, this Truth in Lending Act is enforced by the Federal Reserve Board, applies to all residential loans, not the commercial loans. Residential loans. Contains provisions related to proper disclosure of terms. Terms must be clear and conspicuous and must be actually available. So this kind of an ad is the ad that is a problem with the Truth in Lending Act, because this ad looks like everybody gets 0% down and free payments and $11.98 a month. Does not state that this is only to qualified buyers. So by making this offer without stating that it's only to qualified buyers, they are actually required to disclose all of the terms and conditions of the loan. So they're actually required to make a full disclosure. You watch TV commercials and you'll see when they offer you a certain kind of a deal on a lease on a car, sometimes at the end of that commercial, they'll have a real fast talking guy come on and he'll read all the terms and conditions, because they didn't make it clear that it's to qualified buyers only. Other ads on TV will say you can lease this Dodge Ram pickup for $199 a month, but only to our top tier returning credit truck owners. That's a qualifying statement. So now they don't have to tell you all the terms and conditions. Okay. The next thing we want to talk about is the Real Estate Settlement Procedures Act, RESPA, Real Estate Settlement and Procedures Act. It covers loans on 1 to 4 family homes, and it covers real estate transactions when the property is sold or refinanced with a new first mortgage that's provided by an institutional lender. It's also required on any federally related first mortgages, which means it does not cover seller financing, because on seller financing, there is no institutional lender. So it does not cover seller financing. It does not cover all cash purchases, because on all cash purchases, there is no institutional lender. And it does not cover when you assume a mortgage, because when you assume a mortgage, it is not a new. So it only covers new first mortgages. So what the Real Estate Settlement Procedures Act does not cover: seller financing, all cash purchases, or assuming a mortgage. It also does not cover commercial. It covers loans on 1 to 4 family homes. So it's not covered, does not cover commercial loans or loans on 6 family homes. And that's the Real Estate Settlement Procedures Act. The next one is the Equal Credit Opportunity Act. This is another one that there's a wonderful 60-minute special on. This is an act that makes it unlawful for the discriminator, makes it unlawful for the lender to discriminate on the basis of a lot of strange things. And one of my favorite things in this particular law is that it makes, under the Equal Credit Opportunity Act on page 345, if you go on page 345 on the right-hand column, some of the things that it used to be able to ask people was, are they getting child support or alimony? That's not so bad, but you're not allowed to ask that. But look at the second one. This law made it illegal to ask a woman about her birth control in order to get a loan. And when I first started in the business, it was before this law was passed, and we used to have to ask women if they were on birth control in order to get them a loan. The next thing is a really weird one. It requires an applicant to have a phone number in his own name in order to get a loan. When I bought my first house, I was living at my parents' house, and in order to get the loan for my first house, I had to get Bell Telephone to give me a phone in my own name. And I guess that was when Bell Telephone had the monopoly, and everybody figured if Bell Telephone said you were a real person, you were a real person. So again, now it's no longer legal to require someone to have a telephone to get a mortgage. Can't consider the race of the people in the neighborhood in order to refinance or get a loan. That's redlining. And you can't discourage an applicant because of sex, marital status, or national origin. And you have to consider alimony and child support as income. So the first one says you don't have to disclose it. And the last one said that you have to consider it if they want you to consider it. And again, this is just a cartoon that came out about the time they passed the law. The next one is the Home Mortgage Disclosure Act, HMDA. This act specifically made redlining illegal. And what is redlining? Here's a map of Los Angeles. All the areas that are in red are African-American neighborhoods. And in those neighborhoods, FHA would not insure loans. FHA, under the guidance of Franklin Roosevelt, the hero of all Democrats, would not allow African-American neighborhoods to get FHA loans. And that caused many African-Americans who lived in those neighborhoods, that caused them to have to finance their purchase of their homes with a very poor kind of loan. That's called a contract for deed or a land contract. In a contract for deed or a land contract, you do not get your deed until the final payment is made. So if you've got 360 payments and you miss payment number 359, you lose all your equity and you lose the house. So it's a horrible, horrible way to lend people money. There is a very good article called The Case for Reparations that was it won the prize from the Atlantic magazine a couple of years ago. It was written by Infante Coates, and it's all about how much this redlining hurt the ability of African-American households to build wealth for the last 40 years. Right, so that's the Home Mortgage Disclosure Act. And that made redlining illegal. Redlining is when you take a map and you draw a red line around an African-American neighborhood or whatever other basis you want to use, but it was typically around African-American and Latino neighborhoods, and you say, we are not lending money in these neighborhoods. That is the definition of redlining. And you're probably hearing some redlining now because lenders are still using two sets of criteria to lend to African Americans and in African American neighborhoods. Big fines were paid out in Philadelphia a year ago, and there's a 60 Minutes show on that. So Google 60 Minutes on redlining, and you can watch the show on 60 Minutes. The next thing is the Fair Credit Reporting Act, passed in 1971. This required the credit reporting agencies to delete out-of-date information, to give consumers access to their files, to give consumers the right to correct misinformation. It limits them from sending your information to everybody, and it also gives you the right to get your report every year. I hate to keep pointing to 60 Minutes, but there is a 60 Minutes special on this, because even though this law gives the right for consumers to correct erroneous information on their reports, the credit reporting agencies never correct bad information. So if bad information gets stuck on your report, watch the 60 Minutes special, and you'll see that people actually had to change their names and get new social security numbers to get bad information off their report. Usually that bad information was because of identity theft. So that's the Fair Credit Reporting Act. The next one is the Interstate Land Sales Full Disclosure Act of 1968. And if you ever want to see how this one works, watch the movie Glengarry Glen Ross. Alec Baldwin, Jack Lemmon, a couple other big stars are in there. They're in a real estate office in Secaucus, New Jersey, and they're selling lots in Florida. They're selling property in Florida. And what the Interstate Land Sales Full Disclosure Act says, if you are selling property in another state and you're marketing in New Jersey, and it needs to be 100 residential properties or more. It needs to be 100 residential properties or more. But if you're marketing those properties late night on TV, this is Eric Estrada's ad, and you're marketing those in New Jersey, even though they're in Arkansas, you still have to obey this land sales full disclosure, Interstate Land Sales Full Disclosure Act. And this law says that if you were up late at night and you see Eric Estrada, he's from Chips, that's the old TV cop show that used to be on in the 80s, and he sells you a piece of property, you have a 7 calendar day period of rescission. So you have a 7 calendar day period of rescission. And 7 calendar days includes Saturdays, Sundays, and holidays. Now, in Glengarry Glen Ross, they were selling lots in Florida, and they would sell lots in Florida to people, and then the people would come back because they had the right to rescind their contract, and the salesman would hide, or the salesman would try to obfuscate what was going on so they could get past the 7 days. And the subplot was they were stealing leads from each other, but the main thing was that they were trying to be dishonest to buyers by not letting them exercise their rights of rescission within the 7 days. So the Real Estate Sales Full Disclosure Act says you have the Interstate Land Sales Full Disclosure Act says you have a 7 day calendar period, including Saturdays and Sundays, to rescind your offer, rescind your contract. And there is a state law, and then there is a federal law that mirrors it. In this law, they have to appoint a New Jersey broker as broker of record, and they have to have a formal prospectus. They have to pay a registration fee, and again, they have to give 7 calendar days for a period of rescission. The next one is the National Flood Insurance Program. This was in the news yesterday because it comes out that they drew the wrong maps for the flood insurance. They underestimated which areas need flood insurance. So this National Flood Insurance Program is run by the federal government. And what it does is it maintains a pool of money. And then if you have a property that has a risk of flooding, you can buy subsidized insurance. Now, this probably isn't fair to people who aren't in flood zones because we can't get subsidized insurance. It's only for people who are within the flood zones. And if a house continues to flood every couple of years and get destroyed, don't you think they would just stop building on that piece of property? But this National Flood Insurance allows them to always get new flood insurance. So again, this is something that's going to come under attack. It's going to come under attack as time goes by. Here's a map of all the different states and how many policies they have in force. You can see that most of the states are bordering along waterways. This is Illinois along the Mississippi River. So, we in the Great Lakes. So we do have a lot of areas of the country that have a lot of policies. All right, the next thing we're going to talk about is the Americans with Disabilities Act, the ADA. In the ADA, the Americans with Disabilities Act does not apply to housing. The American with Disabilities Act does not apply to housing. It applies to employment. It applies to employment. It applies to state and local government. It applies to public accommodation. It applies to transportation. And it applies to telecommunications for the deaf. So again, it does not apply to housing. It does not apply to housing. All right, that's the chapter on federal laws affecting real estate. The next chapter is real estate closing and settlement procedures. Real estate closings and settlement procedures. So what we're going to do for now, I don't want to make everybody go 2 hours again without taking a break. So it's 7:38 now. Let's take a 5-minute break. Everybody can go to their restroom and get a drink. So we're going to take a 5-minute break and then get back to this chapter. Okay. Real estate settlement and procedures. We'll get started again in about 1 more minute. Give everybody a chance to get back again. Sometimes I get carried away and I just, I go on for 2 hours straight. That's too much. Very busy day today. Inventory is getting even lower. The contracts are almost back up to the level of last year, which I think is truly amazing. Hopefully we'll continue. And by the time you guys get your license, everything will be back to normal and there'll be plenty of money to be made. All right, so the real estate settlement procedures, closings and settlement procedures. We have to go over how the statement works and why we're having the statement. So what is a closing? A closing happens on a real estate transaction, and there's 2 closings. The first closing is the mortgage, and that's where the borrower is giving the mortgage to the bank is accepting the mortgage. The borrower is giving a promissory note to the bank, and the bank is accepting the promissory note, and we close the mortgage. That allows the lender to then shoot the money into the buyer's attorney or the buyer's title insurance company. They're the ones that are going to distribute the money to everybody. And they distribute the money based on the sales contract, based on the sales contract. The sales contract is the one that, that gives us the roadmap to exactly how we're going to do it. And then we have the title closing. That's the closing for the property. And remember, we've actually had an equitable ownership interest on the property since the time that we have signed the original agreement, since the time we had a meeting of the minds. That's when we had an equitable ownership interest. So what we're going to do here now is we're actually going to develop a way for us to figure out how to fill out this closing statement. And for people who have taken accounting, this closing statement might be a little bit confusing because this closing statement only involves things that happen at the closing table. So we're going to have to decide what's a debit and what's a credit. What's a debit to the seller? What's a credit to the seller? What's a debit to the buyer? What's a credit to the buyer? So I want you to picture a wheelbarrow full of money, and that wheelbarrow full of money is what the buyer brings into closing. That wheelbarrow full of money is what the buyer brings into closing. And I have had a buyer bring one of those big water cooler jugs, the kind you have in an office, and it has that big thing that has like 10 gallons of water in it. I've had a buyer bring one of those filled with coins to a closing. Of course, the attorney flipped out, and we had to run to the bank to convert that to money. But picture a wheelbarrow full of money that comes to closing. Anything at closing that makes that wheelbarrow full of money lighter, anything that reduces the amount of money in that wheelbarrow full of money, anything that reduces that is going to be a credit to the buyer. Anything that reduces it is going to be a credit to the buyer. Anything that makes that wheelbarrow full of money heavier is going to be a debit to the buyer, or to the borrower. Anything that makes it lighter is a credit. Anything that makes it heavier is a debit. Next thing we're going to look at is the check at the end. The check that says pay to the seller. Anything that makes that check smaller is going to be a debit to the seller. Anything that makes that small check bigger, it's going to get bigger, it's going to be a credit to the seller. Anything that makes his final check bigger is going to be a credit to the seller. Anything that makes his final check smaller is going to be a debit to the seller. And what we're going to do is we're going to have all different types of information, all different types of charges that we are going to have to account for within the closing, within that closing statement. Here's what a closing statement looks like. And there's different entries on the closing statement. By definition, sales price is a credit to the seller, and sales price is a debit to the buyer by definition. So if we look carefully at this, here's the sales price, $291, and you see it's listed as a credit to the seller. And here's the sales price, $291, and you can see it's listed as a debit to the buyer. So a credit to the seller and a debit to the buyer. And so now everything else in here, we're going to use our same convention in order to discover what it is. Is it a debit or is it a credit? And then we're going to be able to fill in our document. Now, in Florida, they give you a data set and you have to fill this stuff all in yourselves. Here in New Jersey, it's a little easier. So let's kind of look line by line. First of all, we can see that the borrower paid a $7,000 deposit. Now, he made that check out to his real estate agent. And his real estate agent put it into his office's trust account. And on the day of closing, the broker wrote a check out of the trust account to the seller. That check doesn't make the seller's check any different in size until he brings it to closing, because when he brings it to closing, that check is going to make the seller's final check smaller by $7,000. We're going to cut off $7,000 off the corner of the seller's final check, which means that $7,000 deposit, as you can see over here, is a debit to the seller. That $7,000 is a debit to the seller, and that $7,000 is a credit to the borrower, that deposit, because that $7,000 is going to mean the wheelbarrow is $7,000 lighter, so it's a credit. And that $7,000 means that seller's final check is going to be $7,000 smaller, so it's a debit. So again, that excess deposit, and that is the hardest one to remember. Excess deposit is a credit to the buyer and a debit to the seller. The next thing we have here is we've got just some kind of a credit. I don't know what the credit's for. Maybe it's repairs, but they're giving the buyer $1,000. So he has to bring $1,000 less into closing. But he has to pay the $1,000. So it's going to make his check $1,000 smaller. Therefore, it's a debit to the seller. So that particular credit, that particular seller credit is going to be a $1,000 credit to the borrower. I'm sorry, a $1,000 credit to the borrower and a $1,000 debit to the seller. Now let's look at the next thing. We're going to look at this $278,000 here. This is the new loan that the borrower is getting. And that $278,000 is a credit to the borrower. And that doesn't make sense because he's borrowing it. But yes, it does make sense because that $278,350 is going to make his wheelbarrow full of cash lighter by $278,350. Therefore, the new loan amount is going to be a credit. It's going to be a credit to the borrower. All right? Now we're going to look down here for an adjustment on the taxes. So city and state taxes from 5/4/2020 to 6/30/2020. That's the end of the quarter. And we see it's going to be a debit to the borrower. And what that means is it means the borrower has paid the taxes all the way up. I'm sorry, it means the seller has paid the taxes all the way up to 6/30. So the borrower is going to live in the house without having to pay the taxes from 5/4 to 6/30. And how much value does that have? It has $409.49. So it's going to be a debit to the borrower because he's not going to pay the taxes now till 6/30 to 7/1, but he's going to own the house from 5/4 until 6/30. So it's going to be a debit to the borrower. And the seller has paid the taxes all the way to 6/30. So he's got to get money back because he doesn't live in the house after 5/4. And how much is he going to get back? He's going to get the same amount. So these taxes are going to be a credit to the seller. So these are paid taxes. He's paid the taxes already. So paid taxes are going to be a debit to the borrower and a credit to the seller. That's paid taxes. Now, if we assume those taxes were unpaid, that means if they were unpaid, what that would mean was that the seller lived in the house. The seller lived in the house for April and then up to May 4th without paying the taxes. So the seller would have a debit and the buyer would have a credit. So paid taxes give a debit to the seller and a credit to the buyer. The next thing is the homeowners association fees. So in this case, from 5/1 to 5/4, was 3 days. The seller said, I'm not paying my May's homeowners association dues. I'm not paying them. And so that means at some point the borrower is going to have to pay them. So that credit is $36. It's going to be a credit to the borrower at $36. But he lived in the house for those 3 days and he didn't pay them. So the seller has a debit of $36. We're going to go down everything that could possibly be on the closing one at a time, and we're going to see whether it's a credit or a debit. So here is a credit, is lender gave the borrower. Now this is a tough one to explain because you see it's in parentheses. So even though it's in the debit column, it really counts as a credit. So he must have given him some money back for the loan. That's what the parentheses mean, is that it's a negative number. It's a negative number in the debit column. But let's not try to figure that out for right now. I don't want to confuse you too much. So we did have an application fee here for the loan, and that means the borrower is going to pay it at closing, which is going to make his wheelbarrow $595 heavier. Therefore, it's a debit to the borrower. We've got a commitment fee of $485. That means it's a debit to the borrower. And we've got an appraisal fee of $85. That means it's a debit to the borrower. And we've got a credit report, debit to the borrower. And we've got an MIP. Anybody tell me what kind of a loan he got? He's got MIP. What kind of a loan does he have? What has MIP?
FHA.
Good girl. Who said that?
Kristen Benavides.
Good girl. It's an FHA loan. It has MIP. Okay. And he's got a settlement fee to Commonwealth. So again, these are all things. Now, remember we talked about that Regulation Z with the APR? Whatever his interest rate is, all of this stuff is also going to get added in to make his APR look a little bit higher. But that's not his real, what they call nominal interest rate. That's just, it's going to make that APR number look a little higher because we have to add all these costs of originating the loan back in. Okay. There's a whole bunch of other stuff that's debits to the borrower. Prepaid interest, homeowners insurance, property taxes. He's escrowing property taxes for 3 months. And remember, that's the most you can escrow. He's getting charged all kinds of little ticky-tack charges. And that's what lenders do. He's getting a title insurance policy. Here's his title insurance policy right here. Remember, title insurance policy is based on purchase price. It covers the seller. Sorry, it covers the buyer and the buyer's heirs. There's his title insurance policy. Here's the recording fees. Remember, the buyer benefits from recording the mortgage because it keeps the seller from selling it to somebody else. So the buyer is responsible for recording. Then we talked about power of attorney on another night. They gave power of attorney to somebody to record the deed. Here's the homeowner's insurance premium for this year, $649. Up here was the escrow for the next 3 months. Here is the power of attorney, because remember, a power of attorney to sign real estate transactions has to be a specific power of attorney in writing. So the attorney charged them $200 to do a power of attorney, and then they charged $70 to FedEx. Okay, so those are all debits to the borrower. because they made his wheelbarrow heavier. This is all extra money he had to throw onto his wheelbarrow. And then over here on the seller side, the seller has to pay realty transfer tax. So that's a debit to the seller, the realty transfer tax. This is his second quarter taxes to New Brunswick. He has to pay those. Remember, we had a debit and a credit on the other side to balance that out. And here's his final water bill to the city of New Brunswick. Okay, so those are all things that are going to show up on the closing statement, and they're all things that we're going to have to remember. A couple more things here. Here's my favorite by far. Here's the one I'm always looking for, the commission to Remax Best, right there. That's what I'm always looking for. And that's a debit to the seller, okay? We've got a debit for a homeowner's statement. This is because the homeowners association charged him for the book and the statement. Here's what the buyer's attorney charged the buyer. Here's a working contribution to the condo association. This is a capital reduction fee. And here's his next quarter's homeowners association fees. So those are all debits to the borrower because they make the borrower's wheelbarrow heavier. These are all debits to the seller over here because they make the seller's final check that much smaller. And again, my favorite is the commissions. That's my favorite. The commissions are my favorite. All right, and what we get in the end here is we get a debit to the seller of $72,876. That's the total of all those different debits we saw. And this is the purchase price. He gets a credit for the purchase price. And if you take that number and subtract that number, then you get that $581.73. And over here we have the borrower side. His subtotals are $309,744. Here is the credit for his mortgage that came in and the $7,000 deposit. And then here is how much cash he has to bring to closing in his wheelbarrow. In his wheelbarrow, he's bringing $23,357.78. And the reason I say he's bringing that money in his wheelbarrow is that money that we're seeing there, this $28,000, this has to be a collected fund when it comes to a closing. He can't write a personal check for this. It either has to be a bank check, or it has to be cash, or money has to be wired in. It can't be a personal check. Okay, that's a closing statement. A couple of things that are always on the test about closing statements is how do we handle a seller-held mortgage? So up here, we have the seller's loan amount, $278,000. What if the seller was going to sell this house to this guy, but the buyer didn't have this $7,000? The buyer just doesn't have quite enough money to close. He doesn't have this $7,000 that we had here. Well, the seller could lend him this $7,000, and that would be a purchase money mortgage. So if the seller was to lend him $7,000, that would be a credit to the borrower because that would be $7,000 less that the borrower would have to bring to closing. And if he lent him $7,000, it would be a debit to the seller because that would be $7,000 less that the seller was getting at closing. Because instead of $7,000, he's getting a mortgage and a note for $7,000. So a purchase money mortgage or a seller-held mortgage is a credit to the borrower and a debit to the seller. Purchase money mortgage is a credit to the borrower and a debit to the seller. Okay? In Florida, they give you a data set. You got to fill this stuff out. You got to do all the prorations yourself. You know, we had prorations on here because this is a proration. We had to know how much per day the charges were. So we had to figure it out from 5/4 to 6/30. So we had to somehow do some kind of a problem where we figured out what the daily charge was and multiplied it by the number of days. So you'll have some proration questions on the test. Not hard, they're simple. On tests, they always use 30-day months. So we don't have to do that little nursery rhyme, 30 days have September, April, May, and November. All the rest have 31, except February, which has 28, sometimes 27 or 29, whatever it is, 29.
Hey, Bruce.
Yep.
In real estate, you're talking about 360 days.
Right.
Which days did not count?
So I'm going to tell you that don't worry about that now in real life, but worry about it in terms of the test. They always use 30-day months to make your math easier on the test, so you don't have to remember what months have 31. Okay. The attorneys will sometimes argue over, and they will use the actual days of the month in the calculations if it's a 31-day month or a 28-day month in February. And I've seen arguments with attorneys about this all the time. So
Thank you.
I don't have an easy answer for you. Don't have an easy answer.
No problem.
All right, this brings us to anti-discrimination in federal fair housing. Really hot topic right now. Oh, by the way, in your book on page 359, it gives you what's a credit and what's a debit. You can memorize all that stuff if you want, but if you remember my little, whatever makes the seller's check bigger is a credit to the seller. Whatever makes the wheelbarrow heavier is a debit to the buyer. Whatever makes the wheelbarrow lighter is a credit to the buyer. Whatever makes the seller's check bigger is a credit to the seller. You can use that convention, or you can memorize all this junk. That's up to you. Okay. All right. The next chapter is anti-discrimination in federal fair housing. That is a very hot button target right now. I understand they're going to make the term master bedroom no longer an acceptable term. So, you know, they've already made walk to the train not an acceptable sentence because handicapped people can't walk. They've already made close to houses of worship an unacceptable term because that expresses a preference for people of a certain religion. So, you know, now they're going to remove the term master bedroom. The mother-daughter suite is a term already that's not supposed to be used, but people still do, but it's not supposed to be used. So again, you know, we want to not express any type of discrimination when it comes to real estate. So this is chapter 20. Somebody had asked for this tonight, and I remembered at the last minute. So let's go over this chapter. And again, it is a very appropriate topic for what's going on right now. Anti-discrimination in federal fair housing. This is a YouTube link that's going to bring you to a little 8-minute video, which I'm going to try to play at the end of class tonight. I haven't mastered playing YouTube videos on the PowerPoint presentation in Zoom. I'm going to give it a try. If it works, it works. If it doesn't work, I'll text you, I'll email you guys this link. But this is a tribute to the Federal Fair Housing Act. President Johnson signed it. It was 50 years old 2 years ago, 1968. He was a brave guy to do this because he was a Southern Democrat. Because of this, he chose not to run for his next term of president. Here's Walter Mondale, a name you might remember. He was a co-author of the bill. And for a Southern Democrat, to sign the Federal Fair Housing Act was a very brave thing for President Johnson to do. We're going to start off, though, with New Jersey's law against discrimination in housing. And New Jersey's law against discrimination in housing prevents discrimination on the basis of race, creed, which is religion, color, national origin, sex, gender identity or expression, marital status, civil union status, affectional or sexual orientation, atypical heredity, cellular or blood trait, genetic information, liability for military service, mental or physical disability, familial status with an exemption for senior housing, ancestry, nationality, domestic partner status, and source of income. Those are all things that are prohibited under New Jersey. Now, New Jersey has a poster that all real estate offices are supposed to post. The penalty for not posting the poster is a $100 fine. We're going to find out that that's not a big deal compared to not posting the federal poster. New Jersey's law against discrimination prohibits blockbusting, prohibits racial steering, and prohibits redlining. Blockbusting is when you try to induce people, to sell their home by implying a protected class is moving in, and property values will go down if they don't sell now. So this is New Jersey's law, what it covers, and New Jersey's law has exemptions for if it's a 1 or 2 family home and you live in the house or you live in the second half of the house, you can discriminate on the basis of everything except for race. You can never discriminate on the basis of race. You can discriminate on the rental of a unit in a boarding house, but never on race, just on everything else here except race. And a religious organization, under New Jersey's rules, can discriminate for people of the same religion, but never against race. And we also have a familial status for seniors, which means you can have a building that says no children, if it's a senior building. In New Jersey's law, you have 180 days to enforce it. And the penalties for breaking the rules are $10,000 for the first offense, $25,000 for subsequent offenses, and $50,000 if you have a third or more offenses. Before they will fine you, they give you what's called a conciliation conference, where you will have a meeting and you will try to work out some kind of an arrangement where you will agree to renter the person that feels they've been discriminated against. All right, that's the New Jersey law. Now, every time we sign a listing agreement in New Jersey, we have to give the seller a copy of the New Jersey law against discrimination. So we give them a written copy of the law that explains to them how they can't discriminate. And if they're going to claim one of the exemptions, and race is never a reason to claim an exemption, but if they're going to claim one of the exemptions for the rest of these things here, they can't use a real estate agent and they can't advertise in the newspaper. Okay? The next thing we want to talk about is federal fair housing laws. In the federal fair housing laws, the very first one was the Civil Rights Act of 1866. 1865 is when the Civil War ended. In 1866, they passed a law that said all citizens of the United States shall have the same access to housing, personal property, real property, and contracts as those of white citizens. So that's not a really good way to define this, but from 1866 all the way up to 1968, that's the way we defined it. In 1968, they changed the description a little bit, and they no longer said everybody has the same rights as whites. In 1968, they changed the protected class to say based on race, color, sex, religion, national origin, physical or mental handicap, and familial status. So again, race up here, race was from 1866. That's the year after the Civil War. Race is from 1866, the year after the Civil War. The rest of this stuff was in 1968. So again, society was becoming more sensitive to certain things. So in 1968, in that law, they added those protected classes. In 1988, they also added more protected classes, and it protected handicapped people. So you see here under the 1968 rule, which goes from here to here, no protection of handicap. Then in 1988, they added handicap. So you can't discriminate under the federal rules under handicap. Now, there just was a Supreme Court decision the other day where they extended the federal benefits. The Supreme Court decided they would extend the federal benefits to all these other type things like affectional sexual orientation that New Jersey has. Because up until that Supreme Court decision this week, this wasn't covered. This wasn't covered on the federal one over here. But as of this week, now it's covered over here because the Supreme Court just ruled that it should be covered. So again, very interesting things going on all the time. Under the federal law, Under the federal law, here are the exemptions. Here's where you can discriminate. But again, you can't have a broker and you can't have any advertising. A room in the owner's house, a sale or rental of a religious organization for its own religion, a private club for its own members, and again, that same familial status for senior citizens, with no children for senior citizens. Okay? Now, the penalties are about the same, 10,000, 25,000, and 50,000. If you make a complaint, you have 1 year to file a complaint. 1 year that would result in one of these penalties. And you can also sue for 2 years. So you have 2 years to sue and 1 year to file a complaint. 2 years to sue and 1 year to file a complaint. Under the Federal Fair Housing Act, real estate offices have to have the equal poster hung up in their office. Failure to hang the equal poster, and this is the equal poster, failure to hang this in your office means that if somebody brings a charge of discrimination against you, you, the broker, have to prove you did not discriminate. And if you do have this in your office and somebody brings a charge of discrimination against you, they have to prove you did discriminate. So not hanging this poster up shifts the burden of proof. Not hanging the New Jersey poster up costs you a $100 fine. Shifting the burden of proof could cost you $1 million, because by shifting the burden of proof, if you're found to have violated, you could be responsible for paying all of the legal costs of the person making the claim. And the law actually protects the real estate broker. So if somebody refuses to sell a house to your client because of his familial status or because of his sexual orientation, and you go to court and sue, you can actually get awarded your commission. So again, the law is getting stronger and not weaker. This law is enforced by Housing and Urban Development. You make your complaint to an administrative law judge, and when you make your complaint to them, they're going to hold hearings, and then you'll get a trial if you're going to bring it to a suit. The HUD has ordered there to be proactive enforcement, and they put testers out where they'll have, and you see the commercial all the time where the guy calls up. First he's got an African-American accent, and then he's got a Jamaican accent, and then he's got an Indian accent, and then he's got a Jewish accent, then he's got a Chinese accent, and he gets turned down for his apartment on all of those phone calls. But then he calls up and he puts on a white conservative accent. Guy's name is Graham. I can't remember what his last name is. And the landlord says, I'll rent you the apartment. Well, that's what the testers do. The testers actually make those kind of calls, have different people with different accents call, and they see if you're offering the rental or the sale to everybody, no matter what their race is. Okay? It's very important. The testers go in, send an African-American tester in, then send a white tester into the agent, and they see how you're going to behave. So what they're looking for is they're looking for you treating them differently. They're looking for you treating them differently. And one of the entertainers gave a quote the other day that said, it's so silly, and he's an African-American entertainer. He said, it's so silly that they're making a big deal out of calling something a master bedroom, but they're not enforcing people not showing African-American buyers into certain neighborhoods. And I think that's the truth. I think there is a lot of prejudice out there, and they're not doing a good job of enforcing the laws.
What's wrong with master bedroom?
Because of the, it implies master-slave relationship. It's something that just hit the news today. You'll probably hear it tonight on the news tonight, because it's newsworthy because it sounds strange. All right, more than 500,000 housing discrimination complaints have been processed since 1996. That's a lot. The biggest obstacle for fair housing rights is the federal government's failure to enforce the laws vigorously. I believe that that's true. The three most common types of complaints in 2017 were based on disability, race, and familial status. But disability, you see, is more than half of them. So if you're a disabled person, you are seriously being discriminated against. There is another law, and I think we skipped it. Let's see if I can find it back here somewhere. In New Jersey, it's the multiple dwelling, let's see what it's called, the multiple dwelling reporting rule. In New Jersey, landlords are required to report the racial makeup of their tenants and report that to the state. And that's in any apartment that is 25 units or more. They have to report that every year, no later than January 31st. And the funny thing is, they can't ask for somebody's race at application. They have to compile that information somehow else. But the purpose of that law of reporting what the racial makeup is of an apartment complex is to try to make sure that there is no discrimination. Now, I am going to try my best to see what happens here. If I don't succeed, I think that's my last slide anyway. So if I don't succeed, it means that we're done with class for tonight. If I do succeed, we've got an 8-minute video to watch. Not that one. Just mastering all of this, and not as easy as it looks. Whoops, that's something.
You know what's so sad, man? You know what's wild? Martin Luther King stood for nonviolence. Now what's Martin Luther King? A street.
Try this again. All right, so I guess I have not mastered that yet. I'll try it again next week, and I'll send you the links for that. It's an 8-minute video about the Federal Fair Housing Act, and it's a shows about how much work was done. I don't know if you're getting the sound. That's why I've stopped it, and we'll try to play it again next week, or we'll try to send you a link for it. So I guess that is going to be all for tonight. Anybody has any questions? I'm still here. I'll answer any questions. Let's see. I don't see anything right now. So I guess that's going to be all for tonight. If you want a different chapter, just respond to my email, and I will be glad to. Cover whatever chapters you want. I'm going to be trying to post these things on YouTube. So again, if you
I saw last night class on YouTube today.
good, okay, so it's starting to work. I'm learning how
Yeah.
to do this stuff yet, so everybody bear with me, but we'll eventually get all this stuff on. All right, we got one comment here, and okay. Don't know what the comment is, but it just says Bruce. So tell me, whatever it is, or you can text me or you can email me. But I guess that's going to be it for tonight. And then we'll see you all guys again next Tuesday night. I will try to post some stuff between now and Tuesday on YouTube. And so, guys, I'll send you the links and you guys can watch it, and we can you tell me how it's doing and what I can do to make it better, and eventually we'll make it all better. All right.
I have a quick question. Sorry.
Yep.
I just wanted to know what days of the week is the class going to be on from now on? Tuesday, Wednesday?
Officially, it's Tuesday and Wednesday.
Okay.
But especially as I'm recording the small segments to put on YouTube, I'll be running extra classes just to record those, and I'll invite you guys to them, and you're welcome to tune into them.
Okay.
What I'm trying to do is speed things up a little bit so it doesn't take quite so long, because they're getting closer to allowing testing. And I want as many people as possible to be ready to take the test as quickly as possible. So we will, I'll try to give you extra classes. The ones, though, the normal schedule is still Tuesday and Wednesday evenings. And again, we'll work on that when as we get going. So I guess that is just about it for tonight. I got one request here. I'll take care of off the
I have a quick question, Bruce.
Yes.
Do you know by chance when they will be scheduling this test? Like, is there any chance we can maybe get like August, or is it going to be in the fall?
I think it's going to be in August.
You think August?
I think they're working on it now.
Okay, that's good, at least.
Okay. All right, so then that is it for tonight, and I'll talk to you all. I'll talk to you all on Tuesday, but watch for invites for before Tuesday, and watch for my YouTube channel.
All right, thanks so much. Have a great weekend.
Thank
too.
you.
You too. Have a good weekend.
Thank you very much.
Bye.
Thank you, everybody.
Good night.
Good night.
Bruce.